Beautiful.
Hi, good morning, everybody. Another Zoom meeting. Janelle and I yesterday actually had the first opportunity in 2 years to do a live seminar, which is just awesome. It's just so much better doing these live. But I know it's a lot more convenient for most people to do it through Zoom. So for this meeting, we will do it through Zoom. But at some point in time, we're going to try and get back to doing it live because for us, it's certainly a lot more fun. Always find it very difficult, especially to tell jokes when you don't get the laughter, you don't get the reaction from people. So it's kind of hard. And it's also hard when we're just doing a seminar because you're talking about different topics. It's hard to see whether people really understand because you don't see anybody because nobody has their video on. So hopefully one day we're going to get back to that. But we don't have a lot of time today. We're going to cut this off at an hour. So we're going to get started.
Before we get started, a couple housekeeping matters. If you have a question, throw it in the chat. Between myself and Danielle, we'll be monitoring that chat, trying to get through your questions because I'm going to keep everybody on mute or else this becomes a noise nightmare. This is being recorded. Anybody who couldn't get on or who was busy and can't be here, we're going to be sending out that Zoom link to whomever might want it, and we'll be posting it on our YouTube page. To that end, understand that we are giving legal advice to the best of our ability as of September 16th at 10 a.m. The laws are ever changing, constantly moving and changing, especially procedure in Philadelphia. We have literally done these and an hour later, things have changed. So this is as we know things as of right now, September 16th, 10 a.m. All right, sorry, go ahead, Paul.
Yeah, no problem. And to that point, City of Philadelphia is in major flux right now. We've had 4 council members that have resigned recently, 2 from councilmanic districts and 2 council persons at large. The way it works in the City of Philadelphia is, and this is important to understand because you'll see where I'm going with this with regard to diversion and the new diversion bill that was just introduced. So there's 17 council members in total. 10 of them come from districts. So the City of Philadelphia is divided into 10 different districts. 10 of those members come from each of those districts. I should say one of those comes from each of those districts, in total 10, and then 7 are council members at large. So the entire city votes in those 7 members. 2 of those seats are reserved for minority members so that the Democrats don't have all 17 seats. There's 2 other seats. Used to go to 2 Republicans. Now the Working Family Party was able to get one of those seats, which is basically a Democratic seat. Pretty much so, because that's how she votes. So having said that, 4 of those members have resigned. 2 of those members were from councilmanic districts and 2 were members at large. That leaves 13 members. The problem with the City of Philadelphia, well, it's a lot of problems, but one of the problems with the City of Philadelphia is that the rules say that in order to have a quorum for majority rules for votes to take place, the fact that there's less members now that there's only 13 doesn't change the number of people that you need or members that you need to vote to make up a quorum or to pass legislation. So you still need 9 votes in order to pass legislation. So now it's 9 out of 13 instead of 9 out of 17. So in order to have the extra council members, they give the city council president the right to decide whether or not those other councilmanic seats will come up during a special election. The council president decided that he was going to have the 2 members from the councilmanic districts, those come up for an election in November with the November election, so that under that special election, those people would get seated pretty much right away, so that they would now have an additional 2 members to help them with the quorum and help with votes. What happened yesterday was the mayor vetoed one of city council's bills. That made city council president very upset because now he needs 12 members to override that veto. And he realized in this process that if he only had 13 members, it was going to make it very difficult to be able, there were 15 members to be able to get that veto overridden. So he decided yesterday that he was going to bring up those other two members, the two members that are at large that are no longer there. Those special elections are going to happen in November as well. So all 4 of those seats are going to come up for election in November. What gets really tricky with regard to this, not to get too complicated into the weeds in it, but what happens is that there is now a new law that got passed recently, I guess with the last election, with regard to mail-in votes. So now the mail-in votes are getting delayed because they want to have this special election. And in order to have those nominees on that special election, that all has to be done so many days ahead of time. They got to get it printed and published and all that kind of stuff. So now it's delaying when the mail-in votes go out, mail-in ballots go out. So because of that delay, there's a concern with Philadelphia's voting for the candidates for statewide office. So you got a governor's race and you got senator's race that's happening. So now you're only going to have a month or less of mail-in vote time for those to get out. So they're putting a lot of pressure on the council president to get this done quickly so that that can happen, so that more Philadelphia's votes can be counted in the statewide and the national election. Okay, having said all that, that's kind of the backdrop of Councilmember Gim yesterday introduced the new diversion bill. So under the old diversion bill, there was a sunset provision in there, which we were able to negotiate with her, which said that the bill was only for a 1-year period and ends December the 31st. So Councilmember Gim is someone that's also looking to resign so that she can run for mayor. And by the way, you're having all these resignations, if you didn't know, in order to run for another office in the city of Philadelphia, you first have to resign. So those 4 members that have resigned so far are going to be running for mayor, most likely. 3 have already announced. 1 hasn't yet, but is probably going to announce soon. Helen Ginn is going to most likely be running for mayor as well. So she's going to resign, and David O is most likely going to resign to run as a Republican candidate for mayor. So you're going to have 2 more vacancies coming up. They're not going to be able to get filled in November. So Helen Ginn, realizing that, most likely what the word on the street is that she's not going to resign until after the November election. The concern that she had was that she wanted to make sure that this bill got introduced before she resigns. What City Council used to do before they would introduce a bill is they would send that bill out to all the stakeholders. That's kind of how City Council worked. It was a more congenial body. Now with the new regime that's in there, the new members that are in there, especially the 3 progressives, they don't do that anymore. They just go and introduce a bill. So they don't send it to people ahead of time. They don't ask for your comments ahead of time on a specific language of the bill. They just introduce the bill. So I didn't get a copy of the bill until the day before, Wednesday night, for a bill that's getting introduced on Thursday. It's kind of ridiculous. Have I been in touch with them and going over different things that we want to see in the bill? Absolutely. But at the end of the day, we don't see the actual language that they're going to use, which makes it very, very hard to contest it beforehand. It's actually impossible because then they just go ahead and introduce it, which is what happened yesterday. The bill got introduced, which leads us to where we are today. And then to Janelle's point, everything just changes daily, and we're just waiting to see what else is going to happen today in City Council. So I've been promised that this is just an introduction of a bill, that they're going to be talking with us and other stakeholders, and there's going to be a lot of negotiation that goes on before the final bill gets passed. It's going to have to be done as amendments. Do I trust them? Do I believe them? See Janelle shaking her head. Yeah.
I wouldn't.
Yeah. So we'll see what's going to happen with regard to that. We'll see what happens with the next person that takes up the bill when Helen resigns. She's going to try and get it to a committee before that happens, and to a committee hearing. It's another problem because with all the resignations that have taken place, they don't have quorums on the different committees. City Council President has promised that he's going to go ahead and reassign all the committees and have enough members so that there is enough for a quorum on the various committees. We'll see what happens with regard to that. They're not sure exactly which committee this bill is going to go into. Council President has full authority with regard to that to decide what committee to put it into. So there's just so much that's up in the air with regard to this.
So what does it say as of right now, Paul?
Okay, thank you. Sorry, it was a long time to get to there, but
Yes.
I thought it's helpful to at least have the background so that you know what's happening with this and where the fight is on the bill. So the first thing the bill does, or I guess the last thing in the language, but first thing for my purposes, is that it extends the period for the diversion bill and doesn't have a deadline to it. I was told, and sort of we talked about it, that there was going to be this 2-year sunset provision in there, similar to the last time there was a 1-year sunset provision. I was told it was going to be 2 years. This new bill does not have any sunset provision. So it's permanent. It's going to last forever the way it's written. Between us, it also doesn't have an effective date. I guess that's a technicality. Maybe they'll realize that. Maybe they won't. I won't draw it to their attention. It's kind of interesting because in the initial bill, it says effective at a certain date, and then it ends 1 year later. This new bill just crossed that out. So yes, so now based on that, there's no ending date. But my argument is going to be there's no starting date either. It's an aside. Okay. The other thing the bill does is it says that the bill ends, and this is going to be the council members' argument as to a sort of a sunset provision. So it's not a timeline sunset provision, it's a contingency sunset provision. So it says that the bill ends when the courts come up with a diversion program that would be post-filing, which is what I've been pushing for all along. Is to have that diversion or mediation take place after you file the court case. So right now, the way diversion works is you have to file with diversion and then wait 30 days before you can file your court case. What I would like to see happen is that this be under the auspices of the court, and that you first file your complaint in court, and then it goes to diversion. The advantages of that are many. Number one, you don't have the 30-day delay because the period of diversion would run concurrently with the hearing notice. So if you were going to get a date 30 days out or 45 days out, however long it is right now, the diversion period would be running concurrently with that. So if there's a 30-day diversion period, it would run within the time frame before you would get to court. So there wouldn't be any delay. It's the bottom line. Right now, that's
great. Yeah.
Yeah, right now there's the 30-day delay. The other advantage of having it run through the court system is if you do have an agreement that you're able to reach with the tenants, that agreement would be a judgment by agreement. So that if the tenant violates that agreement, you wouldn't go back to court. You would then be able to just file an affidavit saying that the tenant breached the agreement and be able to immediately file for possession, the writs of possession. So that would be helpful as well. And the other thing that we're really pushing hard for is that if it does go to diversion and the tenant breaches the agreement, and you do have to have a hearing under the process that is happening now, we want to be able to get an expedited hearing. You shouldn't be at square one if the tenants breached the agreement. You acted in good faith, you went to a diversion hearing, you reached an agreement with the tenant breached that agreement. Now you got to go and start your court process. You shouldn't have to wait 45 days to start the court process. You should be able to get a hearing right away. So that's one of the things we're pushing really hard to make happen.
And how likely
So,
is it that all these things are going to actually be in there?
Yeah. So a lot of these things depend on the courts. They're really putting a lot of pressure on the court to come up with a diversion program that is post-eviction filing. And the other thing that they snuck into this bill that they introduced yesterday was that there basically has to be a record sealing before the diversion program as it exists today would go away. So two things have to happen. The court has to come up with its own program, and the fact that you're able to file the complaint right away, that complaint would have to be sealed, meaning it wouldn't be public record, and that's going to be a very difficult thing to make happen. That cannot happen on a citywide basis. That has to happen from the state. So that becomes a nightmare in trying to make that happen, if it happens at all. And a lot of landlords are totally opposed to a sealing bill. So we'll see what happens with regard to that. So that's kind of where we're at with the new diversion law. People had asked me to do a seminar like we're doing today on diversion. And we were trying to set this up, and then all of a sudden everything's changed. And the day before we're actually having the seminar.
Okay, so with everything that's changing, and that's kind of what's on the horizon, and once everything kind of gets finalized, which doesn't sound like it's going to be for the end of the year, we'll do another one of these. But in the meantime, I don't know if Lux wants to jump in, or Paul, you want to start. Can we talk about how things stand as of today, from now, I guess, until what will be the end of the year?
Yes. So the way it is today, before you can file for an eviction case, you first have to send a notification of rights to the tenant. And you have to make sure you're sending the correct notification of rights. The city has changed that form, and if you don't use the correct form, they will not allow you to go ahead and file for diversion. So you want to make sure, if we're not doing it for you, that you're sending out the correct notification of rights. Otherwise, everything's going to get turned away. And be careful, because that may change again with the new legislation that's out there. The second thing that you have to do after you send out the notification of rights is file for diversion. It's not called mediation, although people think of it as mediation. It's called diversion. The difference is, I've learned, I always thought it was just a different word for mediation. They do not have to have mediation in diversion. It's just diverting you from being able to file your eviction complaint, basically. It's a 30-day diversion.
You're adding more time to your eviction, essentially.
Yeah, exactly.
That's all it is.
Yes. So what's happening now is that if you don't meet certain criteria, you don't even get a mediation hearing. They send the tenant a letter. The letter says to the tenant to go and contact your landlord and try to reach an agreement with your landlord. If you can, that'd be great. If you can't, oh well. You still can't file your eviction complaint, which is ridiculous. Everyone I've spoken to from the city and the people that have run this program say, yeah, off the record, we agree with you, but we're not going to change it. We're just going to still make you wait to 31 days. So that's kind of where that's at. The other thing, just as an aside, is there's no regulations that have been passed with regard to diversion, which is absolutely insane. I've been pushing the city for this as well. How can you have a program?
You good?
I'm sorry. Yeah, it kind of blew down. How can you have a program where there's no actual rules for how the program works, which is basically what they have? Any other program that's initiated, they come up with regulations and how to run that program. With diversion, there are none. So right now, you file the notification of rights, you file with diversion, you wait your 31 days, and then you file your complaint. That's the process for diversion. Anything you need to add, Lux, on what you're seeing we're missing from people, or what's slowing the process down, or anything like that?
It's just the court dates. They're out pretty far. So you're going to get court dates that are in November. And if you have Section 8, then they're already out to December. So just keep that in mind when we're filing. We're getting the soonest dates that we possibly can.
One of the things that happened down there, and Andrew can probably talk about it, is that they have these lawyers of the day now. And the courts are not allowing us to have the bulk cases that we used to have in the past. The courts are basically saying you can't come down here with the number of cases that you had. The judges basically say, we want these cases in front of us by such and such a time, or we're defaulting them. And the problem is, these lawyers of the day are jumping on any cases where the tenant shows, where we used to be able to just negotiate with the tenant and be done quickly, making the process a lot longer. Am I missing anything, Andrew?
No, that's absolutely correct.
So on top of the court dates being pushed far out, we're not able to kind of blow through them on non-payments the way that we used to. Additionally, the courts, the judges, they're finding, as Paul was saying before, you know, it's the whole point of the diversion too. They're finding any reason to rule against us. They're trying desperately to keep what they're calling eviction numbers down, so that they can report that.
And one of the things that the tenant organizations had snuck into the original diversion bill, which I tried to get out but was unable to do that, is that it says that the judges sua sponte, and I'll explain what that means, can raise issues for the tenants. Sua sponte means they can do it. It's always
On their
Latin
own
word.
accord.
Yeah, thank you, on their own accord. It's just Latin words to make lawyers sound like they know what they're talking about. They confuse people. Gotta love it in the professions. But anyway, what it basically says is that the judge on its own, on their own, can raise issues on behalf of the tenants. Normally what happens when you go to court is the plaintiff brings a case. If the defendant doesn't object or argue against it, they lose. There's no objection to what the plaintiff's saying, case is over. What this law, however, diversion says, is that the judge, even if the tenant doesn't show up for the court hearing, the judge on their own can bring up the issues on behalf of the tenants. It's absurd. So what's happening is that the courts are now looking to find any way possible on behalf of the tenants to raise any issue that they can address or find to overturn the case. So you're seeing a lot of cases where tenants don't even show up, which is just insane. It should normally be a default that takes 2 seconds. Now the courts on their own are saying, oh, they're finding some stupid reason to not rule in your favor. This is
If I may
crazy.
add to that,
Sure.
if I may add, yeah.
Please.
What I've seen is that both judges and the lawyers of the day are looking for reasons to continue the cases at any means necessary, and they've been granted, the judges just granted continuances for almost no reason at all if they want to. So that's what I've seen there in court.
Yeah, because they certainly have the right to grant a continuance at any time. That's something that judge can just do on their own. So as Andrew said, they don't need a legitimate reason to grant a continuance. And if they want to on their own, they can just grant the continuance or on suggestion of a lawyer without even the tenant being present. It's crazy.
What
What
three
they're
things.
doing is delaying the eviction, so hopefully they can come up with a reason to keep them in the property or come up with the money or whatever. Again, delaying those eviction numbers that they're very much so trying to keep down, so they can report on a national level that our evictions are decreasing.
If there's a tenant that you really want out, we highly recommend that you or a representative of your property show up to court. So if it does go in front of a judge, we can try to oppose that continuance. If you're not there, then we have to accept it because we can't try a case without a client.
Yeah, that's another big thing. You know, we used to be able to put a case up, cross-examine the tenant to see if they've made payments, and that was the end of it. That doesn't work anymore. Judges are ruling against us if our client isn't there. There are certain judges that say, don't even put the case in front of me. If you don't have a client here, we rule against you immediately. It literally just happened in the past couple weeks, or we had a case where that happened. So if there's a tenant that you know is going to show and you know is going to be a problem, we're going to need a representative down at court. It's the whole ball game has changed since COVID. It really has. I mean, the courts and the legislator are using COVID as a reason to advance, this anti-eviction attitude.
That's essentially what's going on nationally. Is there's an anti-eviction attitude. I am now on a task force through the White House. There's over 75 members on the task force. There's only 5 of us that represent landlords, so you can just see how slanted it is. And at the first meeting of the committee, they had Matthew Desmond as the #1 speaker, who, for those of you who don't know, is the one that wrote the book titled Evicted, and that started this entire movement. So that everyone, the group idolizes him. I was ready to throw up, quite frankly. But yes, there's 3 things that are happening nationally that they're pushing for. #1 is this diversion remediation. And it was kind of interesting because they used Philadelphia as the example for the diversion program that they're trying to push for nationally. It was kind of nice to see Philadelphia be mentioned in the national spotlight. It's kind of terrible that they're using
Not for the reasons why, though.
So it's kind of rough there. Second thing they're pushing for is right to counsel. So they want every tenant to have an attorney be allowed to represent them. Right now in Philadelphia, there's 2 zip codes if the tenants live in that they have a right to counsel. And that's going to be expanded as soon as there is additional funding. There are studies that show that for every dollar spent on an attorney, for an eviction attorney to represent a tenant, the government saves $11. It's crazy. But if you think about it, just asking for a continuance, which they pretty much do on every case that an attorney is involved in. So you get a 30 or 60-day continuance. Sometimes they get a continuance at the second listing as well. And then they try to negotiate the tenant to be able to stay for an additional period of time. That saves the government money, because if someone's going to be out on the street, social services, unemployment, there's so many factors that go into it. And that's where they come up with this 11-to-1 ratio. So they're pushing hard to have attorneys representing tenants, because ultimately the idea for them is that it saves money. I don't agree with the study. It's easy to lie with statistics, as we all know, but that's what you have, and that's what they're going with. The third thing that they're pushing for is record sealing. So tenants are pushing hard to have records sealed once an eviction complaint is filed, up until the time that you actually have a judgment against the tenant. They want that record sealed so that the tenant can go theoretically and find another place easier. Quite frankly, I think that in some ways they're right. You're innocent until proven guilty. It shouldn't be on the tenant's record until they've actually had a conviction. But it's just like anything else. If there's a public record of it, it should be out there and you should be able to have access to it. That's most likely the one that's going to happen nationally, if not statewide, and if not, somehow the city's going to figure out some way to do it. They can't do it through legislation. They may be able to do it through the courts.
We have
So
a
that's your
question.
3 things that are happening. Yes.
We got a question in the chat. Do we have to go through diversion if we want to evict somebody for a lease violation and no rent is due?
Yes. So under the old diversion program, the answer was no. Under the new diversion program that started in January, that runs through the end of this year, the answer is yes. And under the new law that was introduced yesterday, the answer is yes as well. If there's some imminent harm that the tenant's going to cause, or some major problem that is happening at the property, then you can avoid diversion and go right to court. I can tell you it has to be really, really bad before the court will entertain.
Yeah, think about assaulting your neighbor bad, not overoccupied.
Yeah, exactly.
Really imminent threat, like people are scared that this person's on the property. It has to
Yes.
rise to that level. I get a lot of questions along those lines of, can we make this process any faster? What can we do in this situation? We have a guy who is destroying the property. We have had a guy who's run naked through the hallways. In some of those instances, we can try and skip diversion. You're not getting emergency hearings in Philly with this current climate unless it's incredibly egregious. We're talking about attempted murder, attempted rape. I know it's terrible. And I know there might be some people on this call that I've spoken to in some of these cases that I'm talking about, people running naked through the halls and serious property damage. But you're going to waste everybody's time and money just filing an emergency petition. Okay, Paul, what about if the resident has mental health issues and is harassing other residents?
I guess it depends on how bad the harassment is. As a general rule, they're going to be in a protected class. You're going to have a very difficult time with that case.
One of the arguments I always make is that while we are sympathetic to the situation, we have 800 other residents to protect, or 232 other residents to protect. And it's something the judges like to rest their hats on, because sometimes all they can see is the one that's in front of them. But you have to explain that there's, this many other residents. The problem with the case and what you're talking about, they're harassing the other residents, is you need the other residents to come to court and testify. You can't testify unless you see it with your own eyes what this person's doing. So that case becomes incredibly difficult because you need witnesses, and nobody wants to spend their day in municipal court. So another question, is the old diversion grandfathered in before the new diversion notice was instituted? For example, I had a diversion notice approved a month ago, and now I want to file a court case. I think, Jeanette, I don't know if you're talking about the.
Yeah.
What, Paul?
Yeah, that's fine.
Yeah, okay. Are they talking about the letter? The notice, I guess she's talking about.
Yeah, the notification of rights, they sent the old notification of rights, but as long as diversion was approved, then you're okay. What's happening is diversion has been denying the right to be able to file if you haven't sent the correct notification of rights. I think that's totally wrong. I've been talking to them about that, trying to fix that, because I don't think that they have the right to decide that issue. But the short answer to your question is you're okay.
Okay, so that's it for the questions. Let's Marcella, we can always talk a little bit more about your in particular case you're having. We can figure that out. Okay, I know I want to touch on lead laws at some point too. Do you want to get to that? Because that was another question people had.
Sure.
Okay.
Sure. Hopefully most of you know the lead laws and know to follow them. They've been out for quite some time. We've done quite a few seminars on that. We've done seminars for an hour and a half just on the lead issue itself. Obviously, we won't have enough time today to go through it all. I just want to touch on it. And then if you have any specific questions or concerns or specific issues that you're dealing with, let us know. We can address them separately for you. Just make sure that you get your lead safe or lead free certification on every single unit. In the past, it was just for units where there was a child 6 or under living in the property. Under the new, not so new anymore, law, you now have to get every single unit certified. That certification has to take place on the earlier of your renting of the apartment to a new tenant, the renewal of a lease agreement, or the renewal of your rental application. So within any 1 year period, you're going to have one of those things come up, and you're going to need to make sure that you have the lead safe certification. You should all know what the difference is between lead safe and lead free. Lead free, it means that there is no lead in the property, it's free of lead. Lead safe means there is lead in the property, but it's encapsulated or covered in such a way that the property is now safe. The lead certificates, lead safe certificates, are now good for 4 years. They were originally only good for 2 years. We got that extended to 4 years. So every 4 years, you would have to get that renewed. So
Addition-
once you get that first one, every 4 years, you would have to renew that lead safe certification.
I just wanted to add, when we ask for these documents, like the lead safe and lead free, the CM lead sheet that you would fill out and say, is there a child under 6? Was the property built? It was like 6 questions. That does not suffice in court. We need the actual lead safe or lead free certificate from the lead company.
All right, so you need both. You want that form filled out and then the lead certificate.
The form doesn't even matter anymore. That was just for our notes
Okay,
previously, but now with this new law, it's just kind of, it doesn't matter anymore.
In answer to Melissa's question, yes, the NAA form has already changed. I gave it to them and that it has been uploaded into NAA's forms. So you do now have the new lead certification. So if you're pulling up a lease through NAA, you will get the new lead certification form.
awesome. Okay. ERAP. That was on the list, ERAP going forward.
The phase 4 ERAP ended at the end of September. Is ending at the end of September.
Yeah, we're not there yet.
I'm a little ahead of myself. So it'll be ending in 2 weeks. The city has to have given out all the money through the ERAP program phase 4. That is the federal government's program. It's extremely confusing because there's money coming from multiple sources. That program is going to end as of the end of September, but the city initially appropriated $15 million toward a new program that is just for the city of Philadelphia. It's not a federal program. This is city money. I just found out the other day that somehow, this is amazing to me, they found another $15 million and now they have 30 million, but nobody's real sure where exactly that money's coming from. But they now have $30 million, which is great. It's amazing to be able to put toward this program. What they're going to do is prioritize that money for people that go through the diversion program. So if you have, and when I say diversion program, I really mean mediation program, the mediation of the diversion program. So as I mentioned before, that diversion just means that you're diverted from being able to file with the court system. Not every case goes to mediation. The ones that will go to mediation are the ones where they feel that the tenant has a chance of being able to succeed and being able to pay the rent that is the back rent and the ongoing rent. And when I say they have a chance of being able to pay it, a lot of that chance is going to come from the city funding. So the idea would be the city is going to pay X amount of dollars, whether it's 1 month, 2 months, 3 months rent. They haven't rolled out the details of the program yet, but however much that is, the city would pay that, get the tenant caught up, and then the tenant has the income or means to be able to continue to pay the ongoing rent. They don't want a situation where they're paying the back rent and then the tenant's only going to be evicted anyway. The idea is to keep people in their homes. So they're going to prioritize that $30 million towards people that they believe by paying the money will be able to stay in their homes and not get evicted. That's the goal, right? If you have someone that owes a lot of money over 3 months rent, right now they're not going to mediation, and you're most likely not going to be able to fall into that program and get funding. So it's really people that have just fallen behind. They have some hiccup in their life that has occurred, that they don't have the immediate funding to be able to pay the rent, that this will get them through that period of time. And the idea is to get $15 million every year to go toward this program. So it looks like they actually are working toward making that happen, which is great.
And like other programs throughout the state, does this particular program have a 90-day hold on eviction if you accept the ERAP money?
The regulations for this program haven't been written yet, so we don't know what the guidelines are going to be for it.
Okay.
The idea would be, as I mentioned before, to get the person the money and to see that they do have the means to be able to continue to pay it. I'm guessing there will be some period of time that you won't be able to file for eviction because the idea is not to have these people be evicted. So if they're giving them the funding, they want to make sure that they're going to be able to stay there, and they don't want to see a situation that the tenant falls 1 month behind and now all of a sudden they're being evicted. And additionally, they don't want to see a filing go against the tenant. So that's where the whole ceiling comes in, and just the whole idea of they want to stop evictions from being filed, which is why
The diversion happens.
all the programs are called eviction prevention. They don't want the eviction even being filed. That's the idea.
Okay, we had a quick question going back to lead. What is it landlord do if a tenant is refusing access to the lead inspection?
You can just certify that the tenant is not letting you into the property, and you can upload that to the city of Philadelphia as your lead certification.
Luckily, the lead certification isn't something like we need for like the license or CRS. We're able to proceed without that, and then we could also add a breach in there for failure to allow access.
So we can file for the non-payment plus the failure to allow access, have that certification showing they weren't allowing the access, and then kind of bolsters that argument in court. All right. What are the reasons that judges are using to request continuances on cases?
They don't need any reason, which is the sad reality of the situation. So if anybody asks for a continuance, they just give it to them. So whatever reason the tenant has for wanting the continuance, there is a 99% chance that they're going to get it. Judges are just looking to delay evictions. That's the climate we're living in right now. Do everything possible to stop or delay an eviction.
It's really bad, guys. There's a very good chance if your tenant shows, the case is getting continued. It's not like it used to be. If the tenant doesn't show, we likely can get the default. But even that's not as guaranteed as it used to be. But if your tenant shows, you can almost guarantee there's going to be at least one continuance on a case. It's just the reality of what life is right now. Especially if you're not down at court, because we can't try a case without a client anymore. So if the tenant doesn't want to enter into an agreement, or if there's an attorney on the other side, that case is getting continued regardless. All right.
Okay, just to continue with the eviction process. So we've gone through diversion, explained all how that works. After 30 days, if you still want to go ahead and file the eviction complaint, you have the right to go ahead and do that. Right now, as Amanda said, it's taking about 45 days if you're lucky to get a court hearing date. I'm guessing that's going to get extended because they have so many cases that are out there. If you have a Section 8 property, you're looking at December, I believe it is, that you're getting hearing dates. It's crazy. The problem with those cases is they only hear those 1 day a week. So there's only limited time slots, and they're only hearing so many cases per day. And that's where you get your delay. Then after we go to court, we wait the 11 days, we file the writ of possession. By the way, there is a bill now pending in Harrisburg to speed up the eviction process. That bill is going to hopefully move in January, and we're really pushing hard to make that happen, and using the ceiling bill as leverage, as possibly a compromise to be able to get that eviction, speedy eviction passed, so that you won't have to wait the 11 days. But right now, the way the law is, you have to wait 11 days before you can file your writ of possession. And then after that, you wait, and then you file the alias writ of possession. The landlord-tenant officer is only doing 25 lockouts per day. That's their maximum that they can do in any one day. So we're seeing a lot of delays and actually getting lockout dates because of that, which is absurd, but it's another thing.
Just to go back to Section 8 really quick, we used to be able to schedule for like 2 or 3 times, and now they cut it down to 1 time. So we only have Section 8 in the morning on Fridays. So 1 day a week, 1 time. So that's why the backlog is really piling up. They just started that recently.
Okay, how do we see non-renewals being impacted? Specifically, if the resident is a holdover after the non-renewal is issued and the date has passed. It's like any other breach of the lease. You need to send it through diversion and then send it through court. You're looking at the same process, unfortunately.
The only advantage you have there is that it's easier to win in court. It's a lot harder on a breach of conditions of the lease. When the lease term is over, then you have an absolute right to possession. The tenant will still be able to get their one continuance, not more, but you will eventually be able to get them out.
Yeah.
But you do have to go through the same process, unfortunately. It's ridiculous. You shouldn't have to do it, but there's no exclusion for holdover tenants, unfortunately. And just be aware in Philadelphia, if you have a lease for less than 1 year, that you have to have good cause to evict the tenant or good cause to terminate the lease. You can't just terminate a lease at the end of the term for leases that are for less than 1 year.
Yeah, we
And
do not
also-
recommend month-to-month leases in Philadelphia.
Yeah, and also be advised.
Situations only.
Yeah, and that came about from Councilman Jones. That was his bill. He's now talking about extending that to all leases and making good cause a requirement on all leases. And that's the same councilman who most likely is now going to be the majority leader now that the current majority leader has stepped down. And at some point in time, the council president has indicated he's going to not run for office. Rumor on the street is that he's not going to run next year. And Councilman Jones is looking to be the next council president. The reason I'm telling you that is because it's his bill. So it's a much better chance of it getting passed with him being the council president. More good news to look forward to.
Yay. All right, we have about 10 minutes. Does anybody have any other questions? We just really wanted to do this so that you guys understood what's going on down there. I know Paul has had a number of phone calls. I know Andrew has. I know Lux fields them every day. I know everybody is incredibly frustrated with the length of time from the point you sent it to us to the point you get a lockout. But we needed you to hear what's going on and what the climate of not only the country, but especially Philadelphia is right now. It's not easy right now to get somebody evicted. And everybody is doing everything they possibly can to delay that process as long as possible. And the bigger problem is if you push back on it, they'll just rule against us. And then we're looking at us taking an appeal because they'll just do judgment for the defendant. So it's hard. We're playing the game as much as we can with them, but understand that, you know, it's just very different. It's very different down there right now. It's a disaster. Lux, do you have anything else that I'm missing here?
No, I don't think so.
I
If you come across any questions, feel free to send me an email, me or April. We can answer any questions, and if we can't, we'll escalate it to Paul.
Paul, what else did you want to say? I'm sorry.
I just wanted to ask a quick question. What did the number 0 say to the number 8? Nice spell.
Yeah, because I know there's a follow-up joke to this.
That's it.
No,
All
there's
right,
not.
what? I know you want another one. Those that don't like jokes can get off. What did the number 8 say to infinity? Are you going to lay down forever? I'm done. Thanks, everyone. Take
Thanks,
care.
everyone. Oh, we needed to laugh. Yeah, after that seminar, I guess we did. Again, this is recorded, so if you need to go to people in your team, just reach out to Danielle. She'll get you the link once we get it onto YouTube. It probably will be by Monday. And thanks, everyone. And as always, get in touch with us if you have any more questions.
Bye, everyone.
Bye, guys.
Bye-bye.
Thank you.